We've discussed in an earlier video about the best interest of the child standard that the courts use in making their custody decisions. A natural question is, can the preference of the child to live with one parent over the other have an effect on this decision? Hi everybody, I'm Sean Ramirez, a divorce and custody attorney here at Frazier Ramirez Law in Albuquerque. Generally speaking, a child's preference to spend more time with one parent over another can have an effect on a custody decision. The extent of this effect depends greatly on the age of the child. In New Mexico, once a child turns 14, the court is required to consider the desires of the minor as to with whom he wishes to live. Many clients I've spoken with think that this means that 14-year-old gets to call the shots. However, a court isn't required to follow a 14-year-old's desires if the court doesn't believe such a decision is in that child's best interest. So while it's not a sure thing with an older child, the child's desires can still carry a lot of weight with the judge. And what about with a younger child? Courts will take into account what a younger child would like, but won't usually place as much stock in them. A notable exception would be if the child expresses strong feelings of fear or possibly safety concerns. How does the child's preference get made known to the court? Well, it depends on the age of the child and also what county your case is in, as different counties have different resources available to them. Generally speaking, courts will go to great extremes to avoid having children come to court and placing them in the middle of a custody fight. However, the court can get the assistance from third parties who can relay the wishes of the children to the court. I do have another video that discusses these third parties more. Check it out over on FrazierRamirezLaw.com. I can't stress this enough though. Do not directly talk to your child about who they want to live with and try to get them to express such a desire. Such a discussion can be viewed by the court as coaching your children, which can have a very negative effect on your case. Once again, this has been Sean Ramirez from Frazier Ramirez Law.